Good day everyone, I am NURAINI RAMDHAN. Number 3302124. Today I'll briefly present a case study on Air Asia Berhad and an industrial relation issue during the COVID-19 pandemic. Air Asia, founded in 2001 by Tony Fernandez, is a leading low-cost airline in Asia. The pandemic severely impacted its operation, with over 953 million in losses in early 2020. To reduce costs, the company cut wages and retrenched employees. In June 2020, two senior engineers were retrenched after 16 years of service. They challenged the dismissal, which the industrial court later ruled as unfair and discriminatory, since Air Asia, based on salary, not fair characterized in first-out principle. The court awarded them nearly 800,000 ringgit. This case shows that even in during tough time, company must follow fair labor law like Industrial Relations Act 1967. Retrenchment must be transparent, fair and respectful, especially to the long-serving staff. That's all from me. Thank you.
Free Malaysia today reported that the industrial court has rendered a significant ruling on Air Asia Berhad. The court ruled that it was unjust and wrong to fire so many employees. The court concluded that the layoffs were unfair and the breach of both industry standards and the legal system. The Industrial Relations Act of 1967 and the Employment Act of 1955, which are two fundamental labour laws in Malaysia, are simplified as a result of this judgment. One of the main legal issues in the Air Asia case was the amended Section 30, Subsection 5A of Industrial Relations Act. Before making a decision, the industrial court may review any agreement or code of conduct that the minister has improved under this section. The Code of Conduct for Industrial Harmony, CCIH, is one of the Asia layoff case has set a precedent for the interpretation and implementation of Malaysian labour laws, particularly the Industrial Relations Act 1967 and consequently the Employment Act 1955. The court use of the Code of Conduct for Industrial Harmony in Section 30, Subsection 5A indicates how norms and morals are having a bigger and bigger effects on legal decision. Even if the IRA granted the workers the legal right to fight the firing, consequently, the organization have to be fair, consistent, and open, especially when discussing sensitive matters like layoff. It also show on the need of moral and ethics leadership and obeying the rule to maintaining workplace and harmony.
Good day everyone, I'm AMIRA ZULAIKHA 302131. We talk about the analysis of roles of unions, management and workers in the Air Asia case. Firstly, is the union, though not as strong as the other airlines, played a crucial role in representing ground and technical staff. They advocated for fair treatment and acted as a voice for the employees, especially during retrenchment issues. Next, the management had the responsibility to ensure compliance with labour laws while making business decisions. However, during the COVID-19 crisis, Air Asia's management prioritised cost-cutting and dismissed employees based on salary alone, which led to an unfair retrenchment process and legal consequences. Lastly, the workers, including engineers and flight staff, they are the backbone of Air Asia's operations. They perform critical duties while also holding rights under Malaysian labour laws. Their active feedback and participation, whether through unions or directly to HR, are essential to maintaining industrial harmony.
My name is SAIDATUL AKMAR. My number matric is 301821. So I will be talking about impact on employee and organisation. Let's look at the organisation first. The first one is reputation damage. Many people are upset because Air Asia fired long-time employees just because of their high salary without considering their skill or contributions. These employees help the company grow, so people see this as unfair. This decision affect the Air Asia image and make people think the company is not fair and caring. The second one is legal and financial consequences. The industrial court said that the dismissals were unfair. Because of that, Air Asia need to pay the compensation. This costs a lot of money, especially since the airline industry is still recovering. The last one is operational impact. If experienced aircraft engineers leave, it could affect Air Asia daily operations. These workers have many years of knowledge that is hard to replace. New or less experienced staff may not be able to handle complex tasks as well. They could lead to delay, lower efficiency, or even safety issues. Now let's look at the impact on employees. The first one is financial hardship. Employees like Mr. Ahmad Faisal Sulaiman and Mr. Muhammad Izzuan Nezar, who were fired suddenly, may face serious money problems. So they depended on their salary to take care of their families and plan their futures. Losing their job suddenly can be very stressful, and finding a new job in that industry is difficult. So next one is loss of trust in employers and the system. When workers are fired for reasons not related to their job performance, they may lose trust in the company. Long-serving staff may feel that their loyalty and hard work were not appreciated. This can make them feel unmotivated and worry about their job security in the future. The last one is damage to professional reputation and career progression. It may be hard for Mr. Ahmad Faisal and Mr. Muhammad Izzuan to find their jobs that match with their skill and experience, especially in the current job market. Being out of work can affect their skill and their chance of moving up in their career. they may have to take lower paying jobs that don't match their abilities, which can affect their long-term earnings and job satisfaction.
My name is NURUL IMANINA binti ZAMRI. My metric number is 301868. Now, I will present recommendations for improvement regarding AHMAD's termination case, which was declared unfair and unlawful by the Industrial Court. From legal perspectives, one of the ways that AHMAD could take is follow objective and lawful retrenchment policy. Firstly, AHMAD must avoid terminating employee based on unfair reasons like high salary. This violates labor law principles. They should follow the last in, first out, which is LIFO method, which means long-term workers should be kept on as long as possible, while those who joined the company most recently should be let go first. If there are exceptions, such as poor performance, it must be properly documented. Next, respect employees' legal right under Employment Act 1955. AHMAD must comply with the Employment Act 1955, which includes giving sufficient termination notice under Section 12 and paying termination benefits based on years of service under Section 20. They must also respect all terms in the employment contracts or union agreements. Next, utilize legal consultation and grievance procedures. Before any termination, AHMAD should have consultation sessions and offer alternatives like mutual separation agreement or redeployment. This will allow employees to think and plan on what is the best decision for them to take. Also, set up an internal grievance process and try conciliation with the Director General of Industrial Relations, which we call it as DGIR, before proceeding to court. The company needs to provide a transparent grievance or internal procedures that will allow the employees to voice out their concerns without pursuing legal action right away. Then, there are several things that AHMAD should also improve in management perspective, which is improve workforce planning and ethical decision making. Management must plan workforce needs in advance to avoid relying on employees' termination. The company should explore another option, such as voluntary separation scheme, which is VSS, an initiative that a company offers an option for employees to resign voluntarily, and in exchange, the company will pay some amount of compensation. Other than that, mutual separation agreement, which is MSA, is a mutual agreement that has been made between both employee and employer to end the employment relationship with peaceful and agreed terms together by finding the win-win situation for both parties. The company also can give the employee an unpaid leave or temporary salary reduction, but only with the employee consent and do it with ethically fair. Another recommendation for management perspectives is transparent communication with employees. It is important to ensure transparent communication with employees. The management must share company challenges via internal memos or meetings and give early warnings about potential employee termination. Lastly, strengthen union engagement and industrial harmony. AHMAD should involve unions in major decisions. The company should consult with unions before making any termination, and it is better to allow union representatives to participate in discussions and help educate employees about their rights and options that they have as an employee in the company. Promoting collective bargaining, especially when it comes to preparing the workforce and employment structure.